This hearing is in the matter of case number CFI 052-2021 before Justice Wayne Martin. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Khalifa bin Huwaidan al-Kitbi advocates and legal consultants. Lead counsel is Mr. P.V. Danish. The defendants are represented by DWF Middle East LLP. Lead counsel is Mr. James Fox.
Good. Thank you very much, Charlotte. Well, gentlemen, thank you both for your participation today. As I'm sure you're aware, the function of today's hearing really is to just make sure that everything is in place for the trial, which is due to start in June, and to discuss, I think it's only the logistical arrangements for the trial that need discussion, because as I read the papers, everybody has complied with all the directions that have been made and the matter appears to be ready for trial. Is that the understanding of both of you?
Correct.
Yes. All right. Well, congratulations to both of you for achieving that. That's a great effort. Well done. It's been difficult times over the last year, as we know. So that's a great effort on both parties' part, for which I'm most grateful. Is there anything I've got a few things that I'd like to talk about, but before I do that, can I just invite comments from counsel? Mr. Dinesh, would you like to raise any issues?
In fact, so far as today's hearing is concerned, I think what we are supposed to look into is the time schedule of the trial.
Yes.
The rest of things are somehow both of the parties have complied with.
Yes. All right. So, Mr. Fox, is there anything you'd like to raise?
Yes. So there is one matter just on compliance, and it's not a significant matter, but I am compelled to mention it. When preparing for this conference this morning, I noted that one of the directions was that in respect to the witness statements, they were supposed to be annotated with the list of issues in the margin. That has neither been done by the claimant or the defendant. I don't think it's a significant issue. But obviously it's a matter of judicial assistance. So if there's anything you would like us to do to rectify that.
I don't want to create unnecessary work. I've seen the lists of issues which have been most helpful. If you think there's advantage in doing it, then I'll do it. But if it is, I think, a direction intended for my benefit, I'm happy to waive that and save the parties a bit of money. If that's Mr. Dinesh, do you have any problem with that?
Not absolutely.
All right, good. Okay. Well, perhaps then we get on to some of the issues I wanted to raise, and that is concerning the trial, the hearing, the e-bundle for the hearing. Have arrangements been made for that, or have directions been made? I should have looked more closely at the file, but have directions been made for the preparation of the e-bundle? And if not, we'll need that to be done, won't we? And we'll need a time by which that will be done. And this trial, remind me, is due to start on Monday. I think it's the 21st of June, isn't it? That it, or the 20th of June? I can't remember.
20th and 21st of June.
20th. So it's Monday the 20th. So ideally, the trial bundle should be available early the week before that, so that people can use their page references and so forth. So has any thought been given to how that will be prepared, or who will prepare it, or what the best way of doing that is?
If I may, Judge, I would suggest that the claimant prepares it. They've already prepared a kind of a pretty workable bundle in any event for the purposes of this hearing.
Yes.
We're happy to provide comments on the bundle as it currently stands for the purposes of the actual hearing.
Yes.
And I think it should be a relatively quick.
Well, the bundle, as you say, Mr. Fox, I agree. I think the bundle for this hearing has probably got pretty much everything that we would need. So perhaps I'll leave the two of you to confer in relation to that. But perhaps in order to set a time, because that's, I think, helps focus the mind, get these things done, and also will assist me in my pre-reading. If that could be done by perhaps I'll direct the e-bundle, if that could be filed by Tuesday the 14th of June, would that be convenient for everybody?
Fine, perfect.
It's Tuesday the 14th of June. Now, The other thing is written opening submissions. Has anybody given any consideration to that, or have directions been made with respect to that?
We were supposed to file it, and in fact, we made the draft, but since the trial is postponed a bit, we just kept it as it is, but we can file it as soon as possible.
All right. Well, when do you want to, well, there's a couple of things. First of all, do you want to do the opening submissions simultaneously, or do you want to do them sequentially? And if so, when do you want to file them?
We can file it in advance, so that will be helpful for the other side as well. They can have a look at it. And
you can do it both at the same time. I mean, everybody knows what the issues are, I think. So there's no reason to delay it. What about if we're going to finalise the bundle, it would be helpful if they were in the bundle, the submissions were in the bundle, I think. So could we make the date for written opening submissions, could we make that Friday the 10th of June? So that they can then be incorporated into the bundle. Now, the next question I had was the oral opening submissions. Is it contemplated that you'll each do oral openings?
Yes, Judge, but we would anticipate that they would be relatively short. It's only one and a half day hearing in any event, and I think all the parties will want to get into the factual evidence.
Well, that leads into the next question. It's a relatively short hearing time. Is the time going to be adequate, gentlemen, do you think? Are there going to be issues in relation to time?
Your Honour is referring to conclusion of the arguments, concluding argument on the same day?
Well, I'm just wondering, we've got a number of witnesses to get through, including an expert witness.
Yes.
One of the witnesses, I believe, will need an interpreter. So that always slows things down. I'm just wondering if 2 days is going to be long enough to complete all the evidence and the arguments.
Yes, one of the witnesses is having problem with English, so that may take some more time because translation it may take more time.
Yes. So, I mean, do we need to allocate the time to make sure we finish within the 2 days, or should we just see how we go as we go, or how do you want to deal with that?
In fact, I may require at least 15 minutes time for my opening statements, and there are two witnesses. So for chief examination, if I allocate 15 each, 30 minutes there, and they have two witnesses, so at least if I get at least 2 hours each. So, and my concluding arguments, it may take at least 2 hours more. So put together, it may come to about 7 hours to my side.
Right. All right, Mr. Fox, on your side.
So we also only have 2 witnesses. Well, we wouldn't propose to be necessarily quite as long with them. So probably, in my experience, an hour and a half for each witness would probably be ample.
Does that include your expert?
So sorry, we're not going to be cross-examining our expert and his.
No. So Mr. Dinesh will be give allowed cross-examination.
Yeah.
That's into the 7
hours.
hours.
Expert witness for the claimant.
Yes. All right.
So yes, from our perspective, it's 2 witnesses that we have to cross opening, and then it would depend on whether you wanted oral or written closing submissions, Judge.
Well, that's again, I'm in your hands, gentlemen. Which would you prefer? I have a slight preference for oral closings, but if you would prefer written closings, that's fine as well. If we run out of time, we may be driven to written closings. But I think, can I just suggest that you should prepare for the hearing on the basis that if we can do oral closings, we will. If you're happy with that, because it's only a 2-day trial, we don't want to make a meal out of this. So I think prepare on the assumption that if there is time for oral closings, that's the course we will follow. But if there isn't, or if there for some other reason you want to do written closings, we can do that, and we can look at written closings perhaps augmented by a further oral session if you want. But those are the sort of things we can address as we.
I'm sorry. Only worry I have is, suppose if I would just want to reflect on the answers which I get during the course of trial, then formulating because I may have to cross-reference for the purpose of assisting this court.
Yes.
Judge, if I may make a suggestion that might assist with timing, it would be slightly out of order, but might I propose that we have the cross-examination of the expert witness first? I'm just wondering whether that will crystallise a lot of the issues and will mean that when we come to cross-examining the factual witnesses, it may be that they can be disposed of, certainly from the respondents, from the defendant's perspective. Cross-examination might run actually significantly quicker.
Unfortunately, it is the expert witness of the defendant, not mine. So
the problem I have with that, Mr. Fox, is that, you know, the old saying, an expert opinion is only as good as the facts upon which it's based. So the problem is, if we get the expert in the box and then the evidence differs from the assumptions of fact that have been made by the expert, then there might be a problem, and it might involve us having to recall the expert. So I understand what you say, but I think it would be preferable for the expert to come last after all the factual evidence has been in, so that all possible factual scenarios, hypothetical or not, but all the scenarios possibly open on the evidence can be put to the expert. I think would be the safest course. In terms of oral openings, if you've done written openings, I would expect they'll be brief. It's helpful to me if they're done sequentially, so that the claimant would do an oral opening, then the defendant, do an oral opening. Then we go into the claimant's factual evidence. So, and that would be convenient. And if we do go into oral closing addresses, then the usual rule, of course, would be that the defendant would close first, orally, followed by the claimant. But it may be that for some reason or another, you'll ask to do the closings in writing, and I'll be receptive to that application if it's made during the course of the hearing. All right. Well, is there anything else, gentlemen?
There's only one matter on behalf of the defendant, and that is made reference already to the defendant's witness requiring an interpreter. The defendant's expert, his first language, although he speaks excellent English, his first language is German. We would like to have the option of an interpreter for the expert as well, if you have no objection, Judge.
Well, if he speaks excellent English, why do you think that would be necessary?
My concern is that he misunderstands a question, and the evidence that he gives then it doesn't answer the question that has been raised to him. So whilst his English is good, and obviously you will have seen from his report that that his drafting is very good. English is not his mother tongue, and my concern is that he doesn't pick up on the questions, and then the answers then aren't properly responsive.
Mr. Dinesh?
But the practice is, many things is lost in translation. So that's the difficulty we face. And if he understands the question, of course, there can be somebody to correct it if the answers are not going, or it is not the proper translation. But sometimes it may be yes or no, or maybe a short sentences. So in that case, I think he can continue with English, and wherever it is necessary, he can express better in German and can be translated during the course of time.
Right. Well, I think that corresponds with what I was going to suggest too, Mr. Fox, and that is that we swear the interpreter at the time the expert is sworn, but we leave him in reserve, so that we'll only call upon him if and when necessary. And basically, that will be when it appears that the answer is not responsive to the question, or the expert says that he doesn't understand the question. And if either of those events occur, then we can call upon the interpreter. Is that satisfactory, gentlemen? Yes. All right. Good. All right. Well, then I think the only three directions that I need to make are dispensing with the earlier direction in relation to the annotation of the witness statements by reference to the issues, a direction that the trial bundle will be filed by the claimant after consultation with the defendant, not later than the 14th of June, a direction that written openings will be filed not later than Friday the 10th of June. And otherwise, we'll start at 10 a.m. Dubai time on the 20th of June. In terms of the location of the witnesses, I assume the expert will be in Germany, and I think another one of your witnesses, Mr. Fox, is in Europe as well. Is that going to pose any timing issues, or in terms of the times at which we need to sit?
Nothing that we can't overcome.
All right, good.
Sorry, just there is just a couple of other matters to dispose of. There's also a direction under that the skeleton should be cross-referenced to the list of issues. Would that assist you, or are you happy to dispose of that?
I'm happy to dispense with that as well, Mr. Dinesh. Unless you think it would be of assistance, I'm happy to I mean, it's a 2-day case. There's not a huge amount of money involved. I'm keen to keep costs within bounds. So the quicker you can do these documents, gentlemen, the better. I'm very happy with that.
Sure.
Thank you, Judge. The only other matter is that there's to be an agreed chronology as well.
Yes.
If that would assist you, still.
That would assist me, I think. And could we fix that for the 10th of June as well?
Certainly. And would that be the claimant's obligation to prepare the first draft of that for the defendant's review?
Mr. Dinesh, are you happy to do that?
Yes, Mr. Fox, I'll be fully cooperating with you, and whatever assistance you require from our side, we'll be giving you and assist the court.
All right. Well, if you could get if you can get a draft of that to Mr. Fox in time for him to respond and for you to consider that response in time for the chronology to be in on the 10th of June so that it can go in the bundle on the 14th of June, that would be very helpful.
Absolutely.
Is there anything else?
Thank you, Judge, for the patience.
Well, thank you very much, gentlemen, for your cooperation. And if that trend continues, we should have a smooth running trial. So that's very helpful and encouraging. All right. If there's anything else that arises between now and the 20th of June, you know where to find me. Okay. Thank you both, gentlemen. Cheerio. The court will now adjourn.